Yeah, so Harry Surden helped us over the years in so many ways, but now he's going to do his first job as our new Associate Director of CodeX, which is to introduce the winners of the 2023 CodeX Prize. So Harry, please come up.
Well, thank you for that fascinating panel. As Roland said, I'm Harry Surden, Associate Director of the CodeX Center and also Professor of Law at the University of Colorado. Each year at FutureLaw, we present the CodeX Prize. This is an award given to an individual or individuals for a noteworthy contribution to computational law that has had significant and enduring and positive impact on the field. It is my honor to present the 2023 CodeX Award to three exceptional scholars and educators, Trevor Bench-Capon, Henry Prakken, and Giovanni Sartor. Let me say a few words about these individuals. These distinguished academics have greatly contributed to our understanding of argumentation in computational law and in artificial intelligence and law more broadly. Argumentation theory is the formal study of argument structures, evaluations, and comparisons. It helps us understand in a more formal level the difference between good and bad arguments. All three awardees are pioneers and leaders in AI and law and have been involved in formally modeling argumentation as it relates to law. Their excellent work has been very influential on many scholars, including myself. So let me say a little more detailed words about each of these scholars before turning it over to them for a few words. Dr. Trevor Bench-Capon was an honorary visiting professor of computer science at the University of Liverpool. He's an expert on how arguments depend on different values, especially in practical and legal contexts. He has published many influential papers, notably Persuasion in Practical Argument using Value-Based Argumentation Frameworks in 2003. He is considered a trailblazer in the field of AI and law, having co-authored numerous influential papers and solo authored, and also written articles with our fellow awardee, Giovanni Sartor. So let me introduce Dr. Sartor. Dr. Sartor is a distinguished professor and researcher in AI in law at the University of Bologna and also at the European University Institute. He has published extensively on artificial intelligence and law, computational logic, legal theory, and information technology law. He also serves as the principal investigator of the European Research Council project on CompuLaw. And he has also collaborated with our other two awardees, Trevor Bench-Capon and Henry Prakken. So let me introduce our third awardee, Dr. Henry Prakken. Dr. Henry Prakken is a professor of legal informatics and legal argumentation at the law faculty of the University of Groningen and senior lecturer in computer science at Utrecht University. He's also a well-known expert in AI and law, known for developing ideas and models using logic, argumentation, and computation to solve legal processes. All of these scholars have written many influential works which have furthered our understanding of argumentation theory, and we're really grateful to these excellent scholars, teachers, and pioneers in the field of artificial intelligence and law. So please join me for a round of applause. So thank you. I will turn it over to Trevor Bench-Capon. Each of our awardees will get 5 minutes to make some remarks. Dr. Bench-Capon? Thank you so much. Thank you, Professor.
Thank you for honoring me and my friends Giovanni and Trevor with the CodeX Prize. I'm also delighted to accept. I'm sorry I cannot be with you in person. I'm currently in Germany for a Dagstuhl seminar on normative reasoning for AI, and you see several other participants here around me. You may recognize some AI and law researchers. Now, I'd like to use my 5 minutes to speculate a bit about the future, and to many, this future is determined by tools like ChatGPT and its possible successors. And I saw on your conference program that you will have an afternoon session on this topic, and I hope I can give you some food for thought. Now, for researchers in the symbolic AI tradition, as Trevor, Giovanni, and I, and also many people around me have always been, ChatGPT presents something like an existential crisis. Why would anyone in AI still be interested in our symbolic models of legal argument now that we have something like ChatGPT? Well, I have no definite answer to that question, but I will try to give you some reasons why you should still be interested in our work. It is often said in defense of symbolic methods that they are key to both validating and explaining system behavior, which of course both are very important in legal applications of artificial intelligence. In a court of law, it is useless to know what the answer should be if you don't have the arguments to convince the judge. And the judge is unlikely to be convinced by arguments without sources and backing. With a system based on symbolic methods, we know what it is doing and what knowledge it uses. Now, it is clear that currently the same does not hold for ChatGPT. We don't know what it is doing and we don't know what knowledge it uses. And this can lead to problems. And to give you a small non-legal example from about me, ChatGPT claims, among other things, that I have received several awards in recognition of my contributions to AI and law. Well, actually, the CodeX Prize is the first such award that I am about to receive. And actually, most things that ChatGPT claim about me are false. However, I also know that natural language processing technology is improving at an extremely fast speed, so a successor of ChatGPT may well do much better in just a few years' time. Having said so, I think that at least for the time being, explicit models of legal argument have an advantage when it comes to validation and explanation. That is not to say that I see no place at all for NLP methods in applications of computational models of legal argument. It would, of course, be foolish to ignore the spectacular recent progress of large language models. And I expect that combinations of symbolic and NLP methods will be an important part of the future of AI and law, at least for the time being. And I'd like to illustrate this with an online system that is in actual use with the Dutch National Police. And it's designed by my colleague Floris Becks in Utrecht and his team. And the system is about online fraud. The problem is that every year the Dutch police gets thousands of online complaints from citizens who claim to have been the victim of fraudulent web shops. Now, not all of these claims are serious enough to be investigated. And the system supports the police in identifying those complaints that are serious enough to be investigated. And it combines a rule-based argumentation system, which is essentially a modernized version of the system that Giovanni and I developed 25 years ago, with natural language processing to get the facts from the complaints. The argumentation part tries to build a defensible argument that there is a potential case of fraud that should be investigated by the police. And the rules it uses are based on legislation, case law, and expert knowledge. And the facts to which these rules are applied to build the arguments are taken from the citizen's complaint. And this complaint is, of course, not written in logic. That would be silly to ask that from the citizen. So the citizen can simply enter the complaint in natural language, and then the NLP module extracts the relevant facts from that complaint. Now, I think it's hard to see how the symbolic argumentation part of this system could be successfully replaced in the near future by a tool like ChatGPT. For the police, a reliable and explainable system is, of course, all important. And the current system that they use is validated with legal experts, while its reasoning can be explained with the model of argumentation that it implements. And I think it's hard to see how large language models can improve on this. So this was my illustration of my claim that, at least for the time being, combinations of symbolic and NLP methods will be an important part of the future of AI and law. Well, to conclude my 5 minutes and a few seconds, I once again thank the CodeX committee for honoring me with the CodeX Prize, and I especially like to thank Giovanni and Trevor for more than 30 years of collaboration and friendship, and I hope we can continue for many more years. Thank you.
Let us now turn it over to Professor Sartor for a few 5 minutes of remarks.
Okay, thank you very much. I hope you can hear me. I also would like to thank the Stanford Law School and the CodeX Center for this prize, which is a recognition of my work, but also the work of my very distinguished colleagues, Henry, Trevor, and also for all people working on computational argumentation in the legal domain. I would be very happy to be with you, but unfortunately, I am in Amsterdam now for a parallel event. So I will do the opposite of what Henry did. Henry focused on the future. I will go back to the past and give a kind of autobiographical tone to my speech. Let me share the screen. Okay, I hope you can see the picture that I am trying to present to you. So this is a long and winding road, the story of my work on argumentation. It starts when I was in the 80s. I was much younger than now. I was a law student, who developed an interest in computing and also in legal theory. I went into a master program to learn a bit more on computing, and I discovered computational logic. This prompted me to go back to logic in the legal domain and theories of legal reasoning and deontic logic. But the real discovery for me at that time was logic programming, and in particular the work of Marek Sergot, Bob Kovassi, and Farid Basardi, who also got the CodeX Prize recently. And this showed how you could view a set of logical premises, and in particular a set of legal premises, as a knowledge base that can be used to make automatic inferences. I got interest in particular in negation by failure, which is an interesting aspect of Prologue. Negation are assumed by default until they are contradicted explicitly. And this led me to the issue of the feasible reasoning. How can we make, or can a system make presumptive conclusions that can be withdrawn when there is evidence to the contrary? And the idea was that this is exactly what happens in legal reasoning. And at this point, my cooperation with Henry started. There were logics dealing with the feasible reasoning, the so-called non-monotonic logics, but Henry and I share the idea that the right way to deal with the feasible reasoning in the law, with presumptive reasoning, is through argumentation. In legal reasoning, we get to presumptive conclusions through arguments, but these arguments can be challenged and possibly overridden by argument to the contrary. So in order to support legal reasoning, we needed this kind of argumentation-based systems rather than deductive logic. And then another discovery came up, the discovery of formal argumentation. At that time, some computer scientists, and in particular PM Dung, developed theories of formal argumentation and semantics for them, ways of rationally taking into account conflicts between arguments and determine what should be the outcome. With Henry, we developed ways to deal with priorities, presumptions, and burdens of proof in this kind of conceptual framework. But then came also my cooperation with Trevor, where we focused on different aspects, in particular, how we can assess sets of premises, theories, on the basis of their coherence and their connection to values. And this leads to another line of research, which Trevor in particular has developed, but I also tried to do something with him, which is on the how to make arguments that are based on values, that are worthy because they advance certain values. Another important collaboration with me has been with Doug Walton, leading scholar and argumentation theorist, with whom I've worked in particular with arguments in interpretation. And recently, I have developed some different line of research dealing with argumentation, such as probabilistic argumentation, argumentation with causes, causal argumentation, and the connection between argumentation and try to provide explanations for classifiers and more generally machine learning systems. This is only my experience. There are other lines of research of argumentation, computational argumentation in the legal domain, which I cannot examine, but this is where I am now. I'm older, maybe wiser, but argumentation continues to be the focus of my research. As Henry said, we believe that there will be a future for symbolic AI, and in particular for argumentation, also in the context of machine learning and as a complement to it. So this is the end of my story, and thank you very much again for this prize.
Please thank these three excellent scholars. Congratulations. Thank you for joining us.